Hello, good afternoon to everyone. On behalf of Young ICSID, we would like to welcome you to our book launch series. My name is Anecdotal Information, and I am the legal counsel at ICSID. Young ICSID was established in 2012 to encourage professional development for young lawyers and to provide a forum to discuss ideas and meet other professionals. Today, Young ICSID has over 900 members from all the regions of the world. With these goals in mind, Young ICSID has been organizing a series of online events to give young professionals around the world access to recent developments and information on international law and ISDS. This event will be focused on newly published books, so stay tuned for more information. Today, we're delighted to launch the series with Mr. Commission's and Mr. Moloo's book, recently published book on Procedural Issues and International Investment Arbitration. At today's event, we're joined by participants online as well as in person here in Washington, D.C. Before we get started, I wanted to lay out a few ground rules for our online participants. First, please make sure that your microphones are muted. We ask you not to unmute yourself during the whole presentation. However, we invite participants to submit questions in writing at any point during the event. To do so, please write your question in the message port and send it directly to my colleague Damon Viz Dunbar rather than to everyone. We will address as many questions as possible as soon as the presentations are complete. With that, I would like to introduce our Secretary General, Meg Kinnear, who will be today's moderator. Thank you.
Thank you. Well, welcome to ICSID. We're delighted to have you here. I'd like to start, first of all, by thanking our panelists. From the far end, we have Antonio Parra. Beside him, Jan Paulsen. And beside him are two authors, Rahim Moloo and Jeffery Commission. And I have the book that we're talking about today. And I don't know if any of you have had a chance to look at it yet, but it is absolutely fabulous. And if you are practicing international investment law, it is exactly the kind of thing that you need. There is a huge amount of procedure these days and some very, very specialized procedure. And anybody who is trying to get a practice in this area or studying it academically needs to understand the procedural issues and not just the substantive issues. So we're very lucky that we have these two experts who have written this book, and I think you will find it incredibly useful. Jeffery Commission, as you may know, who is right beside me, is currently the director of Burford's investment arm and underwriting arm. He's based here in Washington, D.C., and was previously senior counsel at Vannon, and before that practiced commercial and investment arbitration at Linkletters, Sherman & Sterling, and most recently Freshfields. And he's written a number of articles, and in fact, before I met Jeffery in person, I came across his incredible charts, which are at the back of the book, and I realized that somewhere in the world there was a kindred spirit, perhaps as anal as me, but who just loved charts and organization, and so I've been a fan of Jeffery since before I even met him in person, and more so now that I know him in person. Rahim is also, he is a Canadian as well. I'm very proud to be surrounded by Canadians today. He is a partner at the New York office of Gibson, Dunn & Crutcher. He's done a lot of international arbitration, complex disputes, and structuring of foreign investments, so looking at it from both angles, as well as sitting as an arbitrator in some of these cases. So he also brings a lot of experience and a real perspective to all of this. As well, he's an adjunct professor at Columbia Law School, where he teaches an advanced course on international arbitration. And he is on the executive council of ASIL, and a very brave soul who's going to organize the ASIL annual meeting this coming year, I understand, which is, for anyone who's done it, knows is an absolutely huge endeavor. So we are delighted to have you here as well. Jan Paulsen, beside him, is, of course, a founding partner of Three Crowns and has published and practiced exclusively as an advocate and an arbitrator in international cases since 1975. Among the many distinguishing things about Jan, he is a member of the Permanent Court of Arbitration, He's a member of Singapore International Arbitration Center, was president of LCIA, president of ICA, and vice president of the ICC International Court of Arbitration. And that's just a bit of a taste. As you know, Jan is extremely distinguished and has practiced in this field, and in fact was on some of the most important first cases that developed foundational principles. So we're really pleased, and thank you for coming today. And finally, but not least, of course, Antonio Parra. Antonio was the first Deputy Secretary General of ICSID from 1999 to 2005, and prior to that was a legal advisor at ICSID from 1990 to 1999. I think normally when we say ICSID, people immediately and very correctly think of Antonio, and he knows more about this organization than all of us collectively put together. So we are delighted that he is here. Antonio Antonio also was very much involved in establishing MIGA, which is, of course, the investment guarantee part of the World Bank, and in preparing the famous World Bank guidelines on the treatment of foreign direct investment. So he has real expertise, and we are delighted to have Antonio with us here today. We wanted to start off with some comments from Rahim and Jeffery about the book, and then we are going to pass to Antonio and Jan, and then we'd like to talk about some specific questions and very much encourage questions and comments from the audience and as well from those on the webinar. So let's start off with our two co-authors, and they'll tell us a little bit about the book and the writing process.
First of all, you may ask, why a book about procedure? It is not the most scintillating of topics, but quite frankly, at the time that Rahim and I agreed and came up with the idea for the book, it was 2013. So you may ask, we're now in 2018. Did it really take you 5 years to write this book? And honestly, it did, partly because we had other commitments at the time and partly because of the scope of the task that we agreed to undertake. But the impetus for the book really arose from our shared experience working as counsel in investment arbitrations. At the time, in 2013, we both happened to be in New York, and we were regularly presented with procedural applications, and not typical ones. It could be a motion for reconsideration. It could be an application for a site visit. It could be a challenge to an expert or a counsel in a case. Basically, procedural applications where you couldn't necessarily find the answer in a book than existing. And more importantly, you couldn't find the precedents on point all collected in one spot. And that was something that we really hoped to do. It was really twofold. One was to, in the text of the book, provide the reader with a rather thorough description of how, procedurally speaking, an ICSID or UNCITRAL arbitration proceeds, from the filing of the request for arbitration or notice all the way to issuance of the award, and to give you a sense of the details along the way, be that the average duration, how much does it cost, how long does it take once you have a final hearing to get to the award, for instance. For me, Meg alluded to it before, but I have for the last decade been interested in collecting the jurisprudence in tables. I was fortunate enough back in about 8 years ago now to work on a book with Jan and Nigel and Lucy Reed, which is still a book that I really use on my bookshelf, The Guide to ICSID Arbitration. They kindly agreed to include tables that I prepared then at the time that were focused more on substantive issues, basically setting out standards of treatment in cases where tribunals where a violation had been alleged, in cases where tribunals had found a breach. Our goal in presenting this book on procedure is to do just that, to provide the user with a collection of all the relevant jurisprudence on the point, along with a narrative guide as to how an arbitration proceeds. This book is not a treatise on substantive principles, and it's not dedicated to one particular procedural application. And the reason for that is simple, because we had page limits, and we could only cover so many issues. And a lot of the book, obviously, a significant portion is the tabular material, so we tried to be as comprehensive as we could. And I'll turn it over to Rahim for some comments about where we are now, because I think we're in a different place than we were in 2013.
Indeed. First of all, thanks for hosting us, and we feel privileged to have such the panelists we do around us. It seems a bit odd that we're being called experts when we're surrounded truly by the experts in the field. But what we tried to do here is to make a modest contribution, and as Jeffrey said, when we started, it was really focused on being a practical guide and of assistance to counsel, to students, those who wanted to learn more about the procedure. In the 5 years since, a lot has changed, and the debate in this field is very much focused on procedure, not on substance. I think 5 years ago, the debate actually was much more focused on substance. And it's about the structure of the system. As we know, there's an UNCITRAL working group that's looking at reform proposals. ICSID is making some changes to its rules. And the debate is very much about, who decides the cases, how are they decided, who gets to participate, how do you ensure consistency in the decision making, should the cases be public. And perhaps it's not surprising that we've moved from substance to procedure in this 5 years, because procedure is obviously very important. International arbitration as a field is really a field of the study of procedure. There was a quote that I read not too long ago by John Dingell, who was the Dean of the U.S. House of Representatives for a long time in 1983. He wrote, "I'll let you write the substance and you let me write the procedure, and I'll beat you every time." He used a word other than beat, but I know this is being recorded, so I'll say beat. But and that's probably true. And so when we look at these proposals for reform, it's important to look at them from that perspective of how important procedure is to the resolution of these disputes. We have everything from proposals for an investment court, which 5 years ago everybody would have thought was a fairy tale, a dream, to some saying an investment court is going to entrench the system, and so we don't want that. So and everything in between. But I think a fundamental problem in this debate, and it's not everybody, obviously there's some very well-informed people, but an issue with this discourse is there's a misunderstanding about the process as it currently stands today. So what is it that we are trying to reform? So everybody has ideas about what they want the system to look like, but I'm not sure that all of the people participating in the debate understand what the system actually looks like today. And so what we found, and in fact we had our first unsolicited book review a week ago or a couple weeks ago, and it was titled, to our surprise, the focus of the book review was about empowerment. It was called Writing for Empowerment. It's not and that wasn't the intention, but what we've realized is we're hopefully helping to shed a light on the process as it is today, so that when we're having this debate, people understand that it's not just the 20 pages of rules that you see, the ICSID rules or the UNCITRAL rules or whatever it is. There is an entire procedure that is well developed, that is thoughtful, we think, and certainly there are room for improvements, but people should understand what the system looks like today. And it's not homogeneous. That's part of the beauty of arbitration. It can be shaped in different ways. But that's really, I think, part of the modest contribution we've tried to make. And I'll end by saying this is not to say we're against reform or anything like that. I don't want to be mistaken as conveying that position. In fact, reform is good for us. It will help us to be able to then publish a second edition of the book. But it's meant to help people understand what the system looks like today. And now we'll hear from the folks who we all really want to hear from.
Antonio, do you want to start?
Jeffrey suggested that in these remarks I focus on experience with issues of procedure from an institutional perspective over time, that's to say, from an historical perspective, and looking, for example, at increasing frequency of procedural applications at present as compared with the situation in the past. And I think when you're thinking about how things have evolved in this respect at ICSID, you have to remind yourself of the much smaller scale that it had previously. ICSID had in the 30 years up until the end of the 90s, it had never more than about 10 staff members and a caseload that grew at a rate for a very, very long time at only about one per year. So you would think, well, that must have been pretty light demands in terms on the staff of the Secretariat in terms of novel procedural issues. And I don't think that's true. I think they were possibly easier to handle because the volume was so much smaller. But on the other hand, you had the exhilaration of knowing that you were dealing in almost every case with an issue for the very first time. And so we received, sort of hair-raising requests, or requests that would be hair-raising in the first year and it turned out to be rather mundane after about 3 or 4 years had passed and we had some experience under our belt. But to give you a flavor of what I'm thinking of, there were the first, not in any chronological order, but just as they popped into my head, the very first request for approval of access and registration of a request for arbitration under the additional facility rules. If you read the additional facility rules now, bearing in mind that they've, as far as I know, only been used for arbitration, that is, in the investment treaty context, you really aren't much wiser as to how the whole thing works if you look at the approval of access provisions at the beginning. So we had to work our way around that. The very first requests for annulment and the what seemed to be a dreadful crisis stemming from the application of the annulment provisions in these early cases in the mid-1980s. Again, I think I suspect ICSID would feel less horrified by these developments now compared to how we felt in those very early days, or bewildered might be a better word. The first request for provisional measures, the first refusal of registration of a request for arbitration, which if you burrow through the files, you'll see it took many, many months for ICSID finally to dispose of that particular case, which in turn reflects how difficult it was for us to deal with. So I think in that respect, it was quite a different time, but not so much because it was particularly easy or very, very placid. On the other hand, I think that we were helped in facing all these challenges by a very detailed set of arbitration rules complemented by institution rules and administrative and financial regulations, all copiously annotated by Paul Saz, who was a wonderful proceduralist, and unfortunately we at the World Bank lost Paul to the UN sooner than I think we would have wanted to, at least in retrospect. But so we had that resource to guide us, but of course in inexpert hands there would be inevitably glitches. I remember I joined the staff of the legal department of the bank in June of 1984, and the following month was the ICSID manager's, Georges Delhome's, month off, and they looked about for somebody to mind the shop in his absence and settled on me, but I didn't know anything at all about ICSID and or arbitration generally. But in any event, I was told that it wouldn't be too awfully difficult for me, and Georges kindly left behind detailed notes on what I should do in the various cases, the 2 or 3 cases that ICSID had at that time, and for developments foreseen during that month. And one of the cases was the case of Atlantic Triton versus Skinny. And Georges said that there was a memorial due in, and if it came on the specified date, then all I should do is circulate copies of it to the parties. And it came in 1 day late. And I looked at the rules, and the ICSID rules said if the deadline is missed, you disregard the filing. And I thought, my God, what do I do? Do I throw this thing away? I think the counsel was some man named Jan Paulsen in Paris. And so I puzzled over that. I sort of imagined what it would look like throwing these things into the trash bin. But then I decided to call this man a professor in Holland, who was the tribunal president, and his name was Peter Sanders. And I called Professor Peter Sanders and I described the situation to him. And he said, "Oh, Mr. Parra, don't worry. The parties are happy. Just send the memorial to them." And I went, "But it says to disregard it." He says, "Mr. Parra, just send them the memorial." So I felt I learned something from that. And another last thing, I think I've used up my allocation of time. Another last thing is that the year I joined, ICSID was just in the process of, I joined the bank, that is. I wasn't working on ICSID matters for some years yet, full time, that is. And the ICSID had just, when I joined the bank, ICSID was just in the process of adopting its first set of amendments of the arbitration rules. And they sailed through the administrative council of ICSID without too many questions or problems, and entered into force immediately on, that was, I seem to remember, I don't know why, it was the date of the Administrative Council meeting, September 26, 1984. And, of course, immediately afterwards, those of us who worked either part-time or full-time on ICSID, were hoping for opportunities for them, the new rules actually to be applied in a case. And if you look at the ICSID convention, you'll see that the arbitration rules in force, the applicable arbitration rules in an arbitration are those in force on the date of the consent of the parties to ICSID arbitration, unless the parties agree otherwise. And of course, since all of these were contract cases back then, none of them, obviously, in none of them was and for a long time, in none of them was the critical date after the adoption of the new arbitration rules. So these rules, they languished for a long time, not being applied in any particular proceeding until in Moloo v. New Zealand, they had their first application, because in that case, the contract of the parties applied for the provided for the applicable rules to be those in force on the date of the institution of the proceeding, which is a very unusual approach, as those of you who follow these things know. So there was that exception, but not too long after that, we had our first investment treaty case. And as you know, the way these things are structured, the consent of the parties is always on different dates. There's the consent of the state in the investment treaty concerned, and then the consent of the investor will typically be in its request to institute arbitration proceedings. So the ICSID institution rules provide that when the consents are on different date, it's the second one that counts for determining the date of consent, which in turn will determine which set of arbitration rules apply. So suddenly we were in a situation with these investment treaty cases where the latest set of rules would always be applicable, or at least that's the way we saw things. So if you go forward to and this, by the way, was a reason, as reflected in our report to the Administrative Council with respect to the 2002 amendments of the rules. This was a reason for keeping the scope of any changes very modest, because you were going to have them applicable immediately. That was our rationale. You will all know what I'm driving at, which is that I don't know what the position will be going forward now, because as I understand from what's been announced on the ICSID website, that what may be in the works is a more ambitious set of changes to the rules. And so my question would be, which set of rules will apply in an investment treaty case? Will you fall back on this provision in the institution rules, assuming the provision is preserved in the changes, or not? I know a different conclusion was reached on a similar set of issues in the context of the amendment of the UNCITRAL rules, but I wonder if the same approach that we saw in UNCITRAL will be followed in ICSID. Sorry, I've gone on too long, but this is a little bee in my bonnet that I had to express myself on. Thanks.
Thank you, Jan.
Antonio, I think you were 1 minute early.
Oh, really?
Can I have it?
Yes, please.
To the authors, let me express my gratitude, because you have scratched an itch of mine. Or put it another way, if I reflect on the thing I like the least about international arbitration, is anecdotalism. Everything is a story, and you want data. I don't know if you may have noticed that people are sometimes referred to as experts and sometimes as specialists, and one word is very pejorative, and that's expert, and a good word is specialist. And if anyone ever calls me an expert, I correct them. If I'm introduced as an expert, I say I'm a specialist, which means this is all I ever do. So I cannot answer any question you ask me usefully. I will say it depends. Sometimes this happens, sometimes that happens. Ask an expert who has done a case once, and he'll tell you exactly what happens in international arbitration, and you'll be gratified and you'll be content, and it's utterly unreliable. This is a book which is not only filled with reliable information about procedure, but there's also data. So you want to know How many times have arbitrators been challenged, and how many times did it work, and who decided the challenges? Article 41.5, how many times has that been tried, and how many times has it worked? It's there. How much do annulment proceedings cost? Well, there's the data, and you can work out your averages, and you can actually tell somebody. I can't tell you about every single case, but I can tell you about it lots because I've read it in this book. So that's quite wonderful. If I look at matters of procedure and go back to the time before Antonio, when my start in ICSID arbitration was at a time when there was no young ICSID, and if there was a young ICSID, I would have been too young to join it. I would have had to join the toddler ICSID. I was in my 20s. And that case was Holiday Inns versus Occidental. It's the first case. And I was lucky to have a junior role in it. And it's the first case, and it had everything. 2 claimants. So how do they get along? State enterprises, questions about to what extent the acts of one can be attributed to the other, national court proceedings in 4 different cities in Morocco with all kinds of nuances in the outcome, and how are the arbitrators supposed to deal with this? So this is handled by 3 arbitrators who have never been ICSID arbitrators before. Actually, it turned out to be 4 arbitrators and 5 arbitrators. Deaths, challenges, upheld, absolutely everything. And this is done by people who've never seen an ICSID arbitration by definition. And back in those days, arbitrators in international cases, there weren't so many international arbitrations, period. So people who tended to sit in international arbitrations were terribly distinguished. And people whose judgment was valued, and they had been on the Supreme Courts of their countries, they had been advisors to kings and queens. One of them had written an opinion, a legal opinion, as Queen's Counsel, which was consistently referred to as sort of a holy pronouncement that India and Pakistan were arguing about as to the meaning of the Indus Water Treaty. It's one of the arbitrators in this case to tell you that these people are much too wise to look at rules of procedure. So they want, because it's their judgment. So a question comes up and they look at each other, they say, send it to him, forget the rule. That unintentionally results in all sorts of interesting things. As a young lawyer, I had the privilege of, in that case, since it was the first one and everyone's discovering it, of dealing extensively with the secretary of the tribunal. Not only that, but I had the privilege of actually dealing extensively with the general counsel of the World Bank and the Secretary General of ICSID. And these 3 people were the same person. Imagine that. The Secretary of the Tribunal, the Secretary General of ICSID, and the Vice President General Counsel of the bank is sitting there every day trying to get these 3 arbitrators to read the rules of procedure, which he had been in charge of as the leading, as the convoking chair of all of the meetings that had led to the ICSID convention and later to the rules enacted pursuant to them. So it was an extremely challenging case, which explains the great need for understanding procedure and how it is to be manipulated. It's unacceptable for parties to think that procedural decisions are being made using some sort of a judgment which cannot be predicted in advance, or just what looks like the right thing, because you fear arbitrariness. And so that has changed a lot as time has gone by. Some of you may know there's a book on the sociology of arbitration, which called the first generation of international arbitrators, when international arbitration first started, as the grand old men, and the up-and-coming generation at that time, when I was no longer a toddler, I was one of them, and we were called the technocrats. Can you imagine that? I'm a technocrat. People who actually read the rules and tried to apply them. As we know today, matters of procedure are tremendously important. The stakes are high, and people pay a great deal of attention to them. I want to please the audience, so I'll take three sexy subjects. Annulments, challenges, and dissenting opinions. Thinking about these things in the future, I think they're quite important. Annulments, what can you do about them? I just have a vision of it, because as it happens, I also, unfortunately for me, saw the first annulment of an ICSID award. That was in Klockner versus Cameroon, and it was one of the first cases where I was lead counsel, and won the case, and had I was honored by a 5-minister dinner down in Yaoundé to celebrate this, which is very big. 5-minister dinner is a big deal in Cameroon. And then the thing was annulled. And the next time I went down to Yaoundé, the prime minister plaintively asked me, how do you answer this question? I said, aren't we allowed to win? And I said, well, very hard to explain. This is the first time it's done, and we have to read it and we have to look at it. The annulment decision was extremely long. And I will only say this. I have the feeling that from the first instant, something went wrong. I can even be indiscreet and say that back in those days, there was a big question about this new thing that was happening, this new thing that was being created. Did it belong to private international law or public international law? And the thought was that one camp has to win and the other one is going to lose. And lo and behold, this case, the first one where a developing country wins, is presided by public international lawyer par excellence, president of the International Court of Justice, Eduardo Jimenez de Rechiga, and he handed down a case in which the claim was entirely defeated. The annulment committee then was presided by a hero of mine, private international lawyer par excellence, Pierre Lalive. And if you read the annulment decision, you will, and if you just bear in mind that there was a rivalry, to whom will this field belong? And you will see the snide remarks about the French language use in the award with a sick or two on every single page. Even when a meaning is absolutely clear, you know something is going on. So I had the feeling. So every nit that could be picked is picked. So this is an accident of history. But that set the tone for what annulments looked like. And I think my view is always when you read Article 56, you have the feeling that you're reading something which pertains to a cassation. So it's no good to start off the first sentence every single time and saying, we do not review anything substantively. And here are the 120 pages in which we're not going to do that. I think the intention was cassation. And everything I see in the Travaux Préparatoires makes me think that. And the adjectives used in Article 56 repeatedly show that this is not supposed to happen often and therefore should be seen very clearly, when it does. Then you look at how much the annulment proceedings cost and how long they take. And I will even be, it's even occurred to me that by definition, every file in an annulment application, by definition, must be bigger than the file in the underlying arbitration. Because first you have to hand in the entire file of the arbitration, because you're going to complain about not answering every question that was raised. And to do that, you have to show absolutely everything, or some bit of evidence wasn't reviewed. So what can be done about this? I just don't know. It might take a different discipline. It might take some clarity. There are different lengths of these procedures. But I point out that this didn't have to happen. And if somebody else had written the first annulment decision, everything would look very differently. Challenges. I said there was a challenge in the very first arbitration. And that had to do with the fact that the great Sir John Foster, whose career had been exemplary in all other ways, just couldn't be bothered to read the rules. He was appointed by the claimants, Occidental and Morocco. It transpired, it's not a secret, that he was very much the favored lawyer of one of the titans of international business, Armand Hammer, the majority shareholder and chairman of Occidental. And this was the lawyer he liked and trusted, and he wasn't working for him at that time, so he could be appointed arbitrator. But somewhere in the middle of that case, probably Chairman Armour had forgotten about this arbitration going on and was thinking about bigger things like Russia at the time. And he said, you know, that Sir John Foster, I want him to come on the board of directors of Occidental. So he said, I'm going to appoint you. And John Foster was very pleased with this. And he said, well, I guess I can't sit in that arbitration anymore because now I'm going on the board. And this is where he didn't look at the rules. And so he said, well, what do I do? But of course, it's really important. If I resign, it's not right that Mr. Hammer and his colleagues from Holiday Inns don't appoint my successor. That wouldn't be right because that's not, the Moroccans have appointed an arbitrator. And so if I'm going to write a resignation letter and I'm going to say I resign, subject to the condition that after my resignation, I will be replaced in the same way that as I was appointed. Whereupon the two other arbitrators considered that and said you all see how silly that was? If he had said absolutely nothing, the rules actually say that if his resignation is accepted by the two other arbitrators, which they would if he asked politely, explaining the circumstances, his successor would be appointed by the two claimants. But an arbitrator cannot impose conditions. You can't say, I'm resigning subject to. What does that mean? If the condition isn't respected, I'm still here, even though I'm on the board. It's just nonsense. And that created that problem. Ever since then, but you did have the rule. What happens? Two arbitrators decide whether the third should disappear. What a funny rule. Where does that come from? That comes from a couple of centuries of interstate arbitration. In the 1700s and the 1800s, there were lots of interstate arbitrations, and there was no such thing as arbitral institutions. So arbitration clauses had to be self-sufficient. And that meant there's nobody, if an arbitrator needs to be replaced, there's nobody to do that. If there's a challenge, the only way to ensure some sort of institutional continuity is to say the tribunal is now comprised of two, and those two will decide on the challenge. And that was the model that Aaron Brockes proposed to the conferences, and that was followed. An accident of history, it's not a great rule. It makes, there have been 121 challenges, thank you very much. 6 of them only have succeeded. But I can tell you that each time a challenge succeeds, 2 arbitrators who've been just sitting with a person and said, now you have to remove because there has been a challenge and you did not resign, which might have been an elegant thing to solve the problem. You're still here and we're going to say that you have to leave. That creates unease. It's not a pleasant thing to have to do. Might I mention that in a 7th case, an arbitrator said, I don't want to decide this. So he's being challenged. And the 2 of us are going to decide. And I say, I don't want to sit on this challenge because I don't feel it's right. I'm being very legitimist, saying, he's a pretty good friend of mine, and I don't feel it's right. So I will write that letter saying, I cannot participate in this proceeding. Whereupon, I'm challenged too. There's something about this which makes it difficult and makes everyone, I think, happier when, as you know, in most cases, somebody else has taken the burden off the shoulders of the arbitrators. I come to my last procedural point, and maybe in the discussion there'll be some more mundane procedural matters mentioned, but dissenting opinions. I had a long discussion over the telephone with Antonio once when I read, it was a case in which I had no involvement at all except reading the results of the case. So it was an ICSID decision on jurisdiction with a brilliant dissenting opinion, which left me in no doubt that the majority was either completely wrong or hadn't thought about the points being made. I didn't know enough about the file to have any view, but I thought that anybody reading these two documents would think that the majority completely missed the boat. And I thought, I just wanted to understand this. So I called Antonio and tried to get something out of it, which wasn't always easy those days. But I said, what are your rules for this? Because I don't understand. Did the two write their decision, and then the third arbitrator wrote this brilliant dissent, and you don't allow the other two to read it? Because that's the only explanation I can possibly have for this circumstance. And he said, we always allow them to read it.
We always require them to read it.
And then they can decide whether they want to answer or not, or reflect. Sometimes a decision with a dissenting opinion is actually stronger for the dissenting opinion because it shows that the majority have actually met the points that could be said against it. And so here is just ships passing in the night, and unfortunately for the majority, the stronger ship was the dissenting one. Nowadays, we have, in a couple of major unfortunate cases, dissenting opinions that are not handed in on time. And that is as wrong as it could possibly be. A dissenting opinion cannot go out under the imprimatur of the institution a year after deliberations have been concluded and the decision of the majority has been handed down. That's just not right. 1 year somebody is sitting picking nits and who knows if the majority could have had an answer to this. But it creates delays, it creates inefficiencies, and it casts a cloud on the legitimacy of the process. And this is surely something I would have thought without reforming the convention or maybe even the rules, just as a matter of practice, to see to it that this cannot happen. You can't stop people from sending seditious literature in envelopes, but you can stop sending it under the imprimatur of the institution and calling it a dissenting opinion, in my view. So those were my views of the sexy subjects, but maybe we can get into some nuts and bolts of us.
Jan didn't tell you what he said after I told him that they had indeed the majority seen the dissenting opinion. And maybe if we have a conference for the 3rd or 4th edition of this wonderful book, you'll squeeze that out of me too.
Just out of curiosity, Jan, what would you do? Refuse to issue the dissent? I mean, you can assume that the institution was doing everything possible to get the dissent and not to hold up the ship, and at a certain point the ship must sail, or you have the problem of an award that comes out 2-3 years later, which I think is even more difficult.
A dissenting opinion that comes out much later. Well, I think you just live with that and people see it for what it is. But it's the idea that it goes out as part of the procedure. And the thing is, some institutions do that. You send it to the institution and say, this is out of time, we take no action on it, we put it somewhere under the table and we don't send it out. So I think that, and then, better yet, now, you sent in statement of fees. What do you think we're going to do with that, sir?
Jan mentioned his involvement in Klockner v. Cameroon, and that it was in that case that we had the first dissenting opinion ever filed by Professor Dominique Schmidt. And this was in the first round of arbitration in that case. And it was on the basis of that experience, if I remember correctly, that in the 1984 arbitration rules to follow, one of the amendments was to impose on a dissenting opinion the same deadline as applied to the final award. So perhaps there, like as Jan was saying, you would just say, it's out of time, sorry.
Is there a difference in the value of a dissent on substantive matters as opposed to procedural matters?
Well, I'm not quite sure. I mean, if you have a large view of what a procedural matter is, I think, I think certainly not. No, I would say no.
I mean, ironically, the latter might have more of an impact on annulment, right? So, yeah.
One of the big issues we wanted to raise is one that you hear often, but it's the whole question of time and cost. And we talked a little bit about the fact that ICSID is trying to amend its rules, and that's one of the big focuses. There's some studies out now that will tell you you can get a commercial dispute through a Canadian or a U.S. court in about 12 to 18 months. We have courts, case managers, and the question becomes, why would you take a dispute to international arbitration if we can't get it out the door in less than 3.5 years, or it costs the parties $4 or $5 million each? And it is a very legitimate question. And how do you manage that issue? Or is there something about international arbitration that means it always has to take this long? Because we've been talking about this for many years, but we don't seem to have, gotten the problem solved.
I think the trite answer is that it starts with case management. This book deals with procedure in investment arbitration, and the authors had to make a terrible choice. We're going to write about procedure in investment arbitration, knowing that there are two different sets of rules which are often used, UNCITRAL and ICSID, and they're not quite, in many ways, not quite different. And so somebody might say, why, I have an ICSID case. Why am I troubling with these pages about UNCITRAL? Actually, it's good for you because you can see how things might be done otherwise. But that was the choice that the authors made. So you have that contrast. I would have thought that there are ways, practice notes, conferences where people talk this stuff through, where without violating the structure, which I think to some extent is anchored in the convention and therefore has that difficulty of something which is difficult to amend, you can still have greater case management in any of the ways which have been discussed. Is it inconceivable that you would have a short hearing before the evidentiary hearing and listen to the parties as to what their case is, with reactions from the tribunal? And then, for heaven's sakes, explain to arbitrators who there seem to be, I've never understood this, there seem to be quite a lot of arbitrators who think that being an arbitrator is the three monkeys, I'm impartial, and therefore I can never show that I'm affected by what anybody says. Whereas if somebody raises a very naff argument, and I look and said, am I showing partiality? Am I prejudging? I am doing that advocate a huge favor. It's not prejudgment. I have to judge sometime. Why should I only judge when there's nothing you can do about it? So as the case goes along, there's no reason why arbitrators can't say, my mind is open, but counsel, you're just, I don't see how this point makes any sense. You just don't get there. And then sometimes you get a brilliant answer, and you say, oh, gosh, I guess that was a dumb question, wasn't it? I've heard arbitrators actually say that. And it makes parties feel really happy that they have this kind of exchange with arbitrators. So that type of thing, I think, would make a lot of stuff go away, hundreds and hundreds of hours of wasted youth.
I have a hearing next week where the tribunal gave us a list of issues, which is extremely helpful. But I think when we talk about time, one of the things that we need to think about is what is it that's causing the time to be as long as it is? The parties determine largely the procedural schedule, right? So they decide how long they want for the memorials. A lot of the times, 4 months is not unusual, right? And so that time is in the parties' hands. What is it that the institution, the tribunal, can do? Well, I think there's two things to think about. One of them is bifurcation and now sometimes trifurcation, right? So we have jurisdiction, merits, quantum, all heard completely separately. I think it's getting a little out of control. And so that's one of the things that inevitably increases time that is within the tribunal's control, where they can streamline procedures. If a jurisdictional objection is not going to dispose of a case, maybe you ought not to bifurcate. Those are the kinds of things. And then the second is how long it takes them to issue the award. We have seen cases where you wait for an award for 3 years, and that's just, the arbitrators don't have enough time, clearly, or there's some fundamental disagreement. But those are two things that are within the tribunal's control, right? Bifurcation, trifurcation, and how long it takes them to issue decisions. The rest of it, the parties are largely deciding that they want the procedure to take that long. And these are complex disputes. Some of them are, billions of dollars, involving complex issues, multiple proceedings. And so sometimes it's not unreasonable to say, hey, we need 4 months to put all the evidence together. But I think it's important to understand why it is that the process takes as long as it does, and what is within the control of the parties, and what is within the control of the tribunal and the institution.
Rahim, how is it, though, that, for example, domestic courts, Supreme Court will give you 25 pages, that's it, but we need 500 pages in account of memorial. All those kinds of different
page limits,
limits.
I completely agree that page limits will help. There's the famous saying that everybody will have heard, sorry, I didn't have enough time and that's why it's so long. But it's out of control, right? But decisions too, right? Like, I think arbitrators feel like to protect their decisions, they need to be 300 pages long, which, as an arbitrator, maybe it's a flaw that I have, but I've never written an award that's longer than probably 40 or 50 pages, because I just don't think it needs to be that long. But again, maybe I'm mistaken, and maybe every award does need to be the size of this book.
And just on the, I've looked at the issue closely about how long it takes from either the close of the final hearing or the filing of the post-hearing briefs, a tribunal to issue the final award. And Rahim's absolutely right. There are outliers that take 3 years. But the more disturbing or the more disconcerting trend is it takes on average a year. So it's a year from final hearing to the award. And, we on a spreadsheet looked at every ICSID case and UNCITRAL cases and broke down the various dates and then looked at the times between. And, that is, there are others, but that is a very significant time period. And we have seen some change. There are some tribunals now in their first procedural order. I know a former Canadian Supreme Court judge, Ian Binney, is now doing this in his first procedural order at the first session. He includes a clause that it doesn't commit to a specific time, but it does address consultation with the parties about when that award would issue from the final hearing. Again, it's not a hard and fast rule, but it's a step in the right direction. It shows the tribunal's willingness to acknowledge what is increasingly seen as a negative about the system.
How about a reverse DCF computation on the arbitrator's fees?
We'd have to get an expert.
Or a specialist.
But Meg, I think that it occurs to me that there's some data which isn't in this book, which would be very interesting to ICSID, and maybe you actually have it already, because it's doable. How many times is it the case that PO1 is agreed by the parties? Because sometimes when I'm sharing a case, I'm surprised that the parties agreed to something as cumbersome as they have. Well, what am I supposed to do?
Yeah,
It's true.
Agreed, and I'm wondering if parties can actually do more. First of all, in selection of arbitrators, information is public about who takes a year and who takes 5 years, and so in a way, you sign on to what you select. Is there some responsibility on parties in that sense? And then again, as you say, Jan, to tailor your first procedural order. Here's the expectation about orders, about awards. Is there anything to that?
I think so.
Absolutely. I reached out to an arbitrator just last week, and he said, sorry, we tried to appoint him, and he said, you guys will be receiving our appointment shortly, but he said no, because he's too busy. And I really appreciate that, because too many arbitrators, I think, just take on too many cases. And that results in one of two things. One is they're unprepared when you get to the hearing, and that's not to anybody's benefit. Or two is you wait for decisions and awards. And so I think arbitrators need to take it upon themselves to manage their time.
And the more cases they have, the longer their awards.
Yeah.
Longer. I can say longer time.
But I think Rahim's experience is one we are seeing at the center as well. The message, I think, is getting through because we are increasingly seeing arbitrators who are saying, I just have too much on my plate right now. So that is actually starting to get through, I think.
And I do think, there's always this debate about what can you talk to an arbitrator about when you're appointing them. And one of the things that we always ask an arbitrator about is what is their schedule like. And I think it is incumbent on the parties, like you say, Meg. The data's all here. How long do they take? And I think also for the institution when they're appointing a chair to take that into consideration.
Yeah, exactly. Good. Do we have questions from the audience? Anyone? We have questions from the webinar audience.
We have a lot of people joining us online as well. We have a question here from Yadira Castillo. She writes, I would like to know your
point of view, and this is for all the speakers, your point of view around counterclaims. It seems that states have the right to present counterclaims against foreign investors, but there are not international binding obligations for this actor. What kind of responsibility could a tribunal find under counterclaims, international or domestic responsibility?
Well, at the risk of speaking too much, because I know people don't want to hear from me, they want to probably hear from the folks to my left. But I think people forget oftentimes in investor-state arbitration that the state can pursue a number of actions in their domestic courts. They have prosecutorial powers. There is an entire system through which the state can pursue the unlawful actions of the investor. The investor is governed by a set of laws. Maybe not in the investment treaty, but they're not rogue actors that are not governed by any law. And so people forget that the investor-state system was meant to equalize that imbalance, where the state had all of this prosecutorial power, all of this authority to pursue actions against the investor in their domestic courts, and the investor didn't have any ability to pursue actions against the state. So the system was very much designed to balance that imbalance, which is why it's structured the way it is. Now, does that mean that within this particular forum, a state should be allowed to bring certain claims? Well, in certain instances, they can. We have an ICSID claim under a license where there are obligations on both parties. But I think people forget that perspective, that historical perspective.
And also, it may be that, obviously with the new treaties that are being executed and signed these days, many of them do include provisions for states to bring counterclaims within treaty arbitrations. What I've seen in practice also is states will bring claims not in the treaty arbitration itself, but in a ancillary or related commercial arbitration that arises out of the concession or lease agreement, whatever kind of agreement there may be, between the investor and the state. So there may be, as Rahim alluded to, other avenues for the state to pursue the claim if the underlying treaty does not allow them to do so.
Well, another topic is there are a number of procedural applications that we see fairly often, but we don't often see them succeed. And so you might think in this category, applications for reconsideration, applications for security for costs, and Jan has alluded to the whole question of challenges and how infrequent it is for an arbitrator to be successfully challenged. So is the question that those kinds of applications in the first place are not well-founded, or is there something in the decision-making on them, or should we somehow be trying to prevent or put some kind of sanction on those kinds of applications that slow down the process?
I think in that regard, a very interesting point made by Jeffery and Rahim in their book, and they correct me if I've remembered this aspect wrong, but that there seems to be a divergence overall among UNCITRAL investment treaty arbitration cases and ICSID ones in regard to the scope for reconsidering prior decisions, and most on the part of the tribunal. And if I remember what you said correctly, is that there seems to be greater reluctance to do so amongst the UNCITRAL cases. And the question that occurred to me in reading that was whether Jeffery and Rahim thought that any part of that was due to the fact that in an UNCITRAL arbitration, the tribunal can render interim awards, whereas in an ICSID arbitration, at least under the ICSID convention, you render only one award. And by definition, in the ICSID context, at least some of the interim decisions are explicitly made subject to reconsideration in the ICSID framework. I'm thinking particularly of interim costs orders, because those will always be subject to reconsideration by the tribunal in its award. I wonder if you saw any reflection of that in looking at that. I myself have been puzzled by some of these ICSID decisions denying the scope for reconsideration completely.
Yes, no, I think you're right in terms of explaining the divergence, if you will, in how UNCITRAL tribunals versus ICSID tribunals have handled the question of a reconsideration application. In doing the book and looking at that issue, what I was surprised by were just how many of these applications there are and just how far back they go. It's not a new development. It's been going on since the early NAFTA cases. We tried in the book to be balanced in our approach. And, this particular procedural tool is used by both claimants and respondents alike. It's oftentimes, in some cases, it's used repeatedly. So you end up in a situation where a tribunal is faced with successive applications for reconsideration of a procedural order with which a party disagrees. And there's nothing in procedural order number one that tells you when a party can file one of these applications. There's no page limit. There's no scope. It's basically a free-for-all. So one thing that we say is, if these applications are going to become so common, and if you look at the tables in the back, they really have, this is something that should be dealt with up front. There should be a framework for it. There could perhaps be a deadline by which you file one, and the tribunal can decide about how it deals with it, whether in an oral opinion, a short procedural order, or a written decision.
And I guess the only caution, obviously, is if you put in a procedure, it may normalize it. And the question is whether we want to do that. And like Jeffrey says, there may not be a choice, right? These are happening. One of the things that I think needs to be done more of is when you have these interim applications, whether it's motion for reconsideration or security for costs or whatever it is, even provisional measures, there is an automatic tendency, I think, on behalf of tribunals to say we reserve costs for the end. But I don't know why an arbitral tribunal can't say, look, whoever wins this case and will award costs, but this particular application, no matter what the outcome of the dispute, was frivolous or should not have been made. And so we're going to award costs on an interim basis. I think it does regulate behavior of the parties when on an interim basis a tribunal says, we're not going to stand for these kinds of applications, and if you make them, you're going to have to pay for them. We had, and to be fair, it was a commercial arbitration LCIA tribunal. It was an interim measures application recently, and maybe I'm saying this because we were on the winning side, but we got an interim costs order. And it immediately had an impact on the behavior of the other party, because I think the client thought, well, we have to be careful how aggressive we're going to be here, because otherwise we're going to be, drip feeding them their fees as we go along. So I think that's one of the things that arbitrators I'd be curious to hear Jan and Antonio's views. I don't know if Meg would express an opinion on this, but why arbitrators are so hesitant or reluctant to award costs as they make decisions.
The answer to that question is you fear that you make things worse instantly. And two parties who are relatively well behaved, suddenly you will have one which thinks, okay, the game's up, it's not going well, they're against me, whatever it is. And all of a sudden, you're sorry that you did it. That's the answer.
Understood.
Whether it's right, I don't know, in any given case.
Yeah, it can have. I can see. It could have either effect, but yeah.
Let's move to another procedural device that's been probably in the last 10 years, we've seen quite a few, and it's the whole question of amicus participation or third-party participation. And the question here is, what is your assessment of the cost-benefit? We've seen a number of recent decisions where the cost inflicted on the parties, mostly for arbitrator time or preparing submissions in response to an amicus, has been commented on by the tribunal. On the other hand, the idea that something that's essentially public interest based would result in cost consequences is probably one that's not especially popular. But I wonder, procedurally, is it time to look at, how useful are amicus? Are the criteria we have useful enough? Do they bring the right amicus to the table? And how should that cost be allocated?
If I were in the institutional position, I would be very interested in what the states say about this. So it increases costs generally, but they all have to comment, because you start with the idea that all kinds of people want to be amicus, and some of them have good things to say, and some of them have valuable things to say because nobody else is about to say them. But a priori, they're saying something which is relevant to the outcome of the dispute, and you have two disputants. And the idea must be that the state isn't doing its job in lots of circumstances. So I'd be very curious as to, as part of the system, how states feel that this aspect of things should be controlled. Because it's very, very difficult for arbitrators. And I have no experience dealing with this, but I can just imagine when you have 20 NGOs clamoring for attention, and now, 20 is too many. Let me pick the 4 serious ones. Are you kidding? That's a determination I really don't want to make.
I think of these wonderful annexes of Jeffery's and Rahim's book, and I think I noticed that, of course, a large number of requests by non-disputing parties to file submissions in the proceeding, and a very large proportion of them accepted by the tribunals. And then apparently, I don't think I think you mentioned that you're not in a position to gauge what of impact the submission had, but I have a feeling, at least, that their impact has been quite slight. And bearing that in mind, and a lot of the theatrics that, I'm sorry to use that word, that surrounded the very first cases that we experienced of this kind at ICSID, I think it would be very helpful to have a provision in the rules, in new rules, to the effect that the tribunal can, for cost purposes, treat an amicus as a party to the proceeding and award costs in case of abuse. And I would think a tribunal wouldn't be too shy of doing that, because in most of these cases it'll be very obvious that there's been some sort of failure on the part of the intervening party to treat this with the seriousness that I think it needs to be treated with. I'm sure they'll go crazy if you do that.
Well, and just on that, there is one example. It's not an ICSID case, but in European steel, there was a tribunal order that suggested that the European Commission should subject itself to the jurisdiction of the tribunal for purposes of cost award. Because when you have an amicus that has a singular purpose, if you will, and is intervening in a number of cases, both ICSID, UNCITRAL, and others. I mean, I'm not sure what the disposition of that order, I'm not sure how it's been dealt with in the final award, but that was one tribunal that did single out that particular amicus as one that may have to absorb costs, because the parties had to, in their briefs, there were several briefs that had to deal with the issues raised by the European Commission.
This has come up in other cases too, where the European Union has,
Both ways? Might the Commission recover costs?
Good question. Possibly.
It would make,
Yeah, I don't see why not.
in the interest of
Yeah,
overall interest of justice,
yeah.
I'm presuming.
Yeah.
I don't see why not.
One of the big critiques of investor state is lack of consistency and lack of coherence. Is that a fair critique for procedural issues, or is that really something that applies to FET and expropriation?
I think it should apply for procedure. I think we all want consistency on procedure. To use one example that came up earlier is reconsideration. What is the status of an interim award in the ICSID context? Some tribunals have said it's res judicata, we're not going to revisit. Others have said, we change our mind. What are the criteria? There is inconsistency right now in certain areas. You don't want to make the rules too rigid, because I said at the outset, part of the benefit of arbitration is the parties can shape the process, but consistency, I think, is equally desired in matters of procedure.
In matters of procedure is the only place where it's attainable, or otherwise said, there is no issue of inconsistency on substantive matters, and I put it this way. If you have a case, which we assume cases have some degree of difficulty, and somebody is thinking about starting a case and goes to see 10 lawyers, and seven of them say, you have a good case, I would do it. And the 3 say, well, you better not. That wouldn't be such an odd experience to have. Let's say in a perfect universe, you were able to do this 10 times with different tribunals. And it turns out that you win 7 times and you lose 3 times, and people will yell and scream about inconsistency. And I say, isn't that exactly what we predicted?
I wanted to finish just with your thoughts on where we go, both procedurally but also substantively. The UNCITRAL Working Group 3, as Rahim was talking about, is looking at reform. And interestingly, they have ensured the mandate only deals with procedure and not substance. But for those who have listened to the conversations, there is a lot of unhappiness with the system, and unhappiness about, in particular, things like party appointment, double hat, those kinds of issues. And I'm just wondering, are these things that can be resolved through procedure and better application of procedure, or are you talking about radical change as some would like to have?
Ask you. Our time is almost up, and I'm waiting. It's time for you to say some indiscreet things about
I'm the moderator.
But if react to this, I would. An institution has a lot more power than it ever uses, I think, and thus it should be, because it compromises its perceptions of legitimacy and neutrality and so forth. But there is quite a lot of power, and I would have thought that pronouncements in some form from an institution about how the institution feels about the problems you have mentioned, double hatting and similar things, all of which I say one thing: none of them are trivial problems. None of them are trivial. And those who say that, we should just live with this are just whistling in the graveyard or something. If the institution gives some indications about how it views these things, I think that will send signals to arbitrators as to whether they should be accepting appointments or exposing themselves to reputational, or worse, subject to challenge and the like, or non-confirmation.
I think, of course, everything that Jan ever says, I agree with. Yes, that too. But just to add smallish point, and I think it's a great service that Jeffery's and Rahim's book has done to really lay out a lot of, as Jan said, data on all of this. And a lot of these criticisms are based on incorrect data or misinformation or willful disregard of the facts. And this double hatting issue is one of them. I think if you really go down the list of appointees to ICSID tribunals, you'll see that it's a quite small minority of individuals concerned. And so, if you read the criticisms, it makes it sound like this is a problem that's rampant, and it isn't. And I think that's one thing that can be done is to address these criticisms sort of full on, because frankly, I think some of them are fairly disingenuous.
And just one final point. I mean, on that, it's a challenge because you have to go one by one. I mean, just a few weeks ago at ASIL, there was a representative from the European Commission who openly, in a panel, in a room with about several hundred people, had said that one of the advantages of having an investment court was that the costs associated with selecting your arbitrator, and he said that would represent between 30-35% of the actual cost of the arbitration, would be alleviated. The data does not support that. The cost of an arbitration, 30% of them are not spent on time selecting your arbitrator. It is an important issue. I can assure you that counsel spend time doing it, but in no way is the percentage that high. But in order to debunk these things, one has to go one by one and show the data. And either people have been reluctant to do so, or there's not been a forum to do so.
Must have been a typo on his talking points.
He was pretty adamant, I must say.
Why don't we close with one more question from the webinar group?
Yeah,
Okay.
happy to speak to the webinar group.
We'll try Martina and then the webinar group.
Yeah. Well, first of all, thank you very much to the panelists. This has been a real treat, especially to hear about the old cases. I work at ICSID and have been here for a long time, and it's so good to see that the same kind of issues arise over again. I wanted to pick up something that Jan mentioned about proactive case management. This is something that we are exploring in our new rules. And you mentioned that the hesitation to do that now is to not be perceived as prejudging the issues and thus not being independent and impartial. But another approach, I think many, at least arbitrators with a commercial background, that the mandate to arbitration comes from the parties. And so you let them run the procedure. If they agree on something that doesn't make sense, you let them. If they want to plead something that doesn't make sense, you let them. And so how do you reconcile proactive management with that kind of approach?
I think perhaps with some skepticism about how clever they are about the way they're running their cases. There's a bit of a habit in the large industry of presenting cases in arbitration, of overdoing it and not missing a single point, and you can be criticized if you don't, blah, 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 blah. But in the end, too much is put in front of the arbitrators in way of written submissions and in evidence. Mm-hmm. And even the most computer-like, machine-like arbitrator cannot assimilate all that stuff. So we'll actually take on board a few things that turn out to be decisive. Now, that's where the clever lawyer spends time really focusing on. So I think that sort of, that they know what they're doing should be treated with some skepticism. And again, I repeat, I've never understood this business that you can't let parties know anything you think until they get the dreaded award. And I will tell anyone in this room and anyone who's listening that the moment I read the claimant's claim, I'm pretty convinced. Because they're written by skillful people and it sounds like they're right. And then, of course, I read the other side and say, oh, wait a second. And that's the dialectic of it all. So I don't think there's anything wrong in reacting to what is put in front of you and to question it. And that sometimes really causes people to start going faster and skip
So that's for
secondary
the
issues.
substance. What about the procedure? Can you force parties to limit the amount of pleadings, the page limits, those kind of issues?
I think there are certain things. You're right that the parties. There's an expectation that the parties will be able to shape the process, but there are other things that the parties are not in a position to be able to ask the tribunal to do. So, for example, the parties would never ask the tribunal, okay, and we've agreed that you will issue a list of issues to us, a month before the hearing, because they wouldn't just never do that. But those are the kinds of things that an active tribunal, in managing a case, might say, okay, this isn't something the parties are going to impose on us for a variety of reasons, but it's something that we can do to help manage this case and to help streamline the pleadings in a way that's at the hearing is going to help us decide the award faster, help them, focus on the issues that we're thinking about. That's just one example that's come up a couple of times, and that's one that makes sense, right? And that you wouldn't expect the parties to agree to because they're not going to tell the tribunal what to do.
Rahim, isn't that exactly the kind of thing that you should be putting in PO number 1 if you're really using it as a case management tool?
Yes, I think so. And then the question comes, as Jan said, I think there is a tendency for parties to agree to basically everything on PO1 with the exception of normally, if it's an additional facility arbitration, the seat of the arbitration, and bifurcation. And so there are a couple of big fights, and it's usually those two are ones that come up time and again. But I think the arbitrator should say, we had a great tribunal that said, well, look, we're going to bifurcate, but in the bifurcation schedule, we're going to provide the timeline for our award, for our decision. And so everybody knows that this is the timeline, and we actually agreed in that case to say, okay, we are going to file our memorial the day after the proceeding. So, it was a cost the client was willing to incur, but if there is an understanding of what the time frame is going to be to receive that decision, then other decisions can flow from that. Likewise with respect to list of issues, etc. So I think there are things that the parties can agree to, but then there are other things that the tribunal can say, this is what we're going to do to help the parties.
I wondered, Martina, if at your question in part, the issues that you're talking about can at least in part or might better be addressed in at least in part by through rule changes where the parties are presented with a set of rules that, for example, instead of leaving it basically entirely to the arbitrators when they will render their award, sets a deadline that might be extended not by them, but, for example, by the Secretariat of ICSID. I think the few occasions in the past where we tried to tackle that aspect of the rules, all we ended up doing was doubling the deadline that was already there, and that is in fact easily avoided by the tribunal. So we didn't have a lot of luck tightening that up. But I wonder if the time has come for ICSID to really crack down in this respect. For example, we tried to inject some sense in what we had as a deadline for appointing arbitrators, and we made it, instead of best efforts, obligation on the part of the Secretariat, and that quickly degenerated, to be quite honest. I can say that because I presided over the generation, but it was a situation where we had a 30 days best efforts obligation, but very, very seldom came even close to meeting that.
Yeah.
And before it was an inflexible deadline, and we always met it.
We are trying to crack down on a number of things in our new rules. Yeah. And one of them is exactly this, but trying to find the right balance. And now we've been focusing on arbitrators and time limits for arbitrators, but the same could be said for counsel, and we have to find the right balance of enabling arbitrators to comply with time limits. And for that, we will need some cooperation from parties too.
And to be sure, I mean, there's also another place where you can have that. And there are a few, again, there's a patchwork of 3,500, give or take, BITs. There are a couple. I've looked at some Israeli ones recently, and they include a time frame. Typically, you see that in state-to-state dispute settlement, but they actually included an investor-state dispute settlement, where a tribunal has to issue an award within 8 months. Or the whole proceeding will take 8 months. So there are, again, these are the exception rather than the rule. But if states really want more expeditious proceedings, I'm not advising this, but there are treaties out there that have it, and there are ways to approach it. With the understanding that there should be some flexibility given to the tribunal in cases where that there needs to be extension or something.
Right. Let's close with one final web question. And Damon?
Okay, so we have a question on standard of review, and Olga Schaefer asks, would a clarification of standard of review
and, for example, on the use of proportionality be useful as a matter of procedure, or do you view it solely as substance rather than procedure? To anyone on the panel.
A clarification on the standard review on procedural issues?
Yes. Would that be useful?
Well, Justin and I have written an article on standards of review, but it was mainly on the substantive context. I don't think we really addressed procedure. But I thought Article 52 kind of did that because that's the annulment standards are largely focused on the standard of review for procedural matters. Annulment is not meant to be a substantive review. It's meant to really review, I always sort of categorize it in two ways, right? It's the right to be heard and the equal treatment of the parties. Was something procedurally improper that didn't allow for an outcome to be achieved that is fair?
You can restate the abstractions in Article 52 in an infinite number of ways with other abstractions, and that's the big challenge. But I think there have been many extremely incisive commentaries, which, rather than giving you abstract phrases, which is the only way you can deal with it in a rule, actually give you some meat into it. And I think those who apply Article 52 owe it to everybody to be conversant with that commentary.
Good. Well, I would like to ask you to join me in thanking our speakers today. And we invite you to join us for a reception just outside of the room. Thanks very much.